Hi, yeah, thank you. Welcome everybody. I also actually changed my title a little bit. First I had conservation law and the implicit intrinsic value of the wild animal. But then later I realized that one of my main arguments is that there is no such thing as the wild animal. So I changed it in a more generic way of looking at animals. I will also be looking at wildlife, but more in a descriptive way, I guess, and just kind of like deconstruct what the law currently is with regards to wild animals in Europe. So I'm limited to Europe in that sense. So first of all, what do I mean with wild animals? Well, for that, I took a part of the definition of the Animal Health Organization, which is that animals that live independent of direct human supervision or control. The full definition of the Animal Health Organization is actually also speaking about animals with a phenotype that is unaffected by human selection, but because the law often recognizes feral animals, such as like cats that have become feral, also as wild animals, I omitted that part and I left it only with regards to the supervision and control. So why are wild animals so interesting, in my opinion at least? It's because they live in like a different reality in a variety of ways. So obviously, spatially, when we think about wild animals or wildlife, we tend to think about them in like a place far, far away, untouched by humans, etc. But of course, they also live near us in like the liminal animals are also wild animals. They live in like the urban jungle, etc. But we don't really see them. We don't interact with them usually, or we fear them. So even though our spaces overlap, they live in a different spatial reality, so to say. Morally as well, they live in a different like realm. So we tend to think of nature as like rat in tooth and claw. There's no moral agents there. It's a existence that is like regulated by the laws of the jungle, by violence, by killing and eating and being eaten, etc., which is something that we tend to shy away from or tend to avoid in like with non-wild animals. So we keep animals separate if they can attack each other, etc. We try to like regulate these moral relationships. And obviously, and most interestingly for today, they exist in a different legal reality. Where we look at individual, like non-wild animals as individuals, and we focus on their welfare. With wild animals, we tend to take a species approach, like a species conservation approach. And this very much relates to this thing that Werner also touched upon already, which is the like holism of environmental ethics and the individualism of animal ethics. And you also see this in law. So, for example, the Berne Convention on the Conservation of Animals recognizes the intrinsic value of wild flora and fauna, whereas like some national legal systems, such as the Netherlands or the new proposal of the Animal Welfare Act of Finland, recognize the intrinsic value of the individual animal. And we'll come back to the notion of intrinsic value later. So first to lay some like groundwork before I will talk more extensively about conservation law specifically. So the general idea is that in Europe or other like Western regimes as well, there's this animal welfarism which is leading, and I'm sure you're all like familiar with that already. But just to reiterate the basics that are relevant here for us. In animal welfarism, the objective is to protect or improve the welfare of the animal, obviously. And this is done, amongst others, through a prohibition on the unnecessary suffering of animals. And this already implies a balancing exercise between human interests and animal interests, where the human interest, like however insignificant, will almost always trump the animal interest, however significant or vital. And in that way, the human interest, or like the human use of the animal, kind of decides the threshold of suffering that is allowed. So this is also recognized by Annie Setz when she applied the interest convergence theory to animal law, which essentially means that whenever there's a convergence between human and animal interests, there's a quite high protection of the animal, and thus like a high threshold of the amount of suffering that is allowed. but whenever these interests diverge, the amount of threshold, or the threshold for the amount of suffering that is allowed gets lower, and more harm can be done to the animal. And she refers to this kind of as like a legal gerrymandering for animals. And this interest convergence theory envelops like animal welfareism as a whole. So in order to see whether it also applies to wild animals, we're going to look at the different categories of wild animals that exist in like the law. These are not legal categories as such, but they can be deciphered through looking at all the different laws that are applicable to wild animals. So I categorize these in like different ranks of animals that you have in the wild in law. So the first rank are those animals that belong to protected species, and this is the best rank you could have as an animal. It basically means that the killing or disturbing or destroying of the animal or of its breeding or nesting site is prohibited. And these protections are therefore quite high, and they have been referred to as animal rights. Most of the animals that end up as like first-rank animals get there because of a rare or endangered status, although cultural considerations can also be a reason for assigning an animal to first rank. And whenever they are, they usually end up as first-rank animals because they're put on like a protective annex of conservation laws. So for example, CITES has different annexes, but also the Habitats Directive or the Berne Convention all have annexes for protected species, and these then ensure the first-rank status. What is interesting or noticeable when looking at conservation law text up close, such as the Berne Convention or the Habitats Directive, is that the status or the protection status is quite related to the exploitation of the species. So in the Habitats Directive, for example, it's explicitly recognized that the level of the species should be compatible with exploitation of the species. And the idea is generally that the species should be kept in a way that is replenishable for future generations. So the Berne Convention also recognizes the importance of animal species to hand them over to future generations. So there's this very explicit exploitative aspect in their protections. And whenever there's a human interest with the animal in question, the human interest still trumps. So the Berne Convention, for example, contains some exceptions to the killing or destroying, etc., of protected animals whenever there's a conflict with the public interest or whenever it's necessary for judicious exploitation, whatever that then may mean. So it's quite open still. And the photo is obviously a wolf. It's one of the protected species in Europe, and it's quite an iconic species as well, and enjoys quite high protections, therefore. So this is the second rank. These are animals that are not protected, but unprotected, a contrario. And these are also often referred to as vermin species or pest species. And interestingly enough, that's also because these species tend to live close to humans, so they're liminal in the zoopolis sense, and thereby cause a nuisance or disturbance to people, and are then subsequently managed or exterminated by people who do that as a profession. And they do, in most European countries, not all unfortunately, but most, they are still covered by anti-cruelty laws. So there is a prohibition on unnecessary suffering also with regards to these animals. But they are not mentioned in conservation laws. So they do not really exist in the picture of biological conservation, basically. And the example is obviously the rat, quite recognizable as a common pest species. All right, then the third and final rank of animals are those that are not only unprotected, but are deliberately targeted. by law, and as such, the law calls for like their complete eradication within a certain territorium or country. And the definition of, these are called invasive alien species, and the definition of them is those species whose introduction or spread has been found to threaten or adversely impact upon biodiversity and related ecosystem services. Which sounds, I guess, maybe fair enough in a way, but there is like a policy, especially, or at least in the EU, that these animals are always guilty until proven innocent. So this adverse impact on the ecosystem does not have to be like proven in any way for eradication programs to already start. And what is also interesting, so usually invasive alien species are thought of in a way of those animals that exist like outside of their natural range, but this is not really how we look at them. So the way more decisive factor is actually how they got there, and when this is like through humans, so human-induced migration, they are regarded as invasive. Whereas if they get there as a consequence of climate change, for example, and they migrate therefore, it is not human-induced and they're not invasive species, even though their impact on the ecosystem, might very well be the same or similar. So there's kind of an idea of control there. So whenever we have caused an invasive alien species to end up somewhere, we want to take them out again. So we want to control the image of nature that we have in our minds, or like this image of biodiversity. And when a species does not belong in that image, regardless of its impact on the ecosystem, which you can also say whether that is really relevant in any way, we tend to aim to eradicate the species away from that image and away from nature. And the picture is a gray squirrel or fox squirrel, and it's one of the 30 animals that the EU formally recognizes as an invasive alien species. So now let's go back to the interest convergence theory that I talked about earlier. So I would like to argue that the interest convergence theory is similarly applicable to wild animal law as it is to the welfarist regime, but it's just in a little bit of a different way, but it's present in both of these legal structures. So where welfarist regime looks at the use of an animal and the human interest in that use, in wild animal law we tend to think of a human interest in the environment, and it's a very specific human interest as such. So it's it's an exploitative interest in a way, and it's also a very static interest. So we want to keep things preserve or conserve things as they are already and not change anything. And this is the human interest in the environment that is then decisive in the level of protection that is applicable to the animals, which you see then in these different ranks. But also similar to the welfarist regime, there's even at even when the interests are most converged, there's still respect for the intrinsic value. So there's still a consideration of the interest of the animal, which is then visible through this bottom line prohibition on unnecessary suffering. However, that's then subsequently filled in, is of course related to the convergence, but it's always there, this bottom threshold. And you see this, for example, with wild animals in the the invasive alien species regulation of the European Union, which is obviously about third rank animals, so it's quite a high divergence with human interests. But even in the IIS, or the invasive alien species regulation, it still mentions that all animals should be spared avoidable pain or suffering. So there's still this bottom threshold of the prohibition on unnecessary suffering, which is also applicable for second rank animals and obviously for first rank animals. And it's just that for first rank animals the interests are converged, so the level of protection is a lot higher. So since I'm talking about this bottom line of respect for intrinsic value, which goes up the higher in ranking you go, it's useful to talk about intrinsic value a bit more in depth and what I mean exactly by that. So intrinsic value is often seen in law as just opposite of instrumental value, but if you look a bit closer at philosophy or legal philosophy, you actually see like a whole range of definitions and meanings that can be applied. So I just want to talk through some that I think are relevant here. So Joseph Raz thinks about intrinsic value as not necessarily non-instrumental, but he makes a further distinction within intrinsic value where he says that intrinsic value is a derivative form of value that is a constitutive part of a valuable form of life. So what does that mean? Well, for example, music has intrinsic value because music is, for me as a human being, constitutive of a valuable form of life. Same goes for like art, for example, or whatever. And for him, only human beings have this like ultimate value. So they are the only ones that like matter in a way, and they are also the ones that, in that sense, decide whatever has intrinsic value because it's relevant for their like form of life. So it's very relational the way he looks at it. Then Christine Korsgaard makes two different distinctions. So she says that there's intrinsic value and extrinsic value, where extrinsic value has its value due to its circumstantial properties. So it's again this like relational aspect. And then she says there's also things that are valued as an end and things that are valued as a means to an end. And furthermore, she states that an entity can have extrinsic value but also be valued as an end, and then it has final value. And as an example, she mentions nature, so that will be quite relevant for us. So again, she looks at nature and also like species, for example, as like in a derivative intrinsic way. And then finally, Ronald Dworkin, he does not really makes a distinction within intrinsic value, but he just states that there's such a thing as sacred intrinsic value, meaning, well, he doesn't really like attach a meaning to it as such, but he mentions that this is relevant for beings such as like fetuses. He applies it to fetuses mostly, but also endangered species. And he basically states like these are entities that don't really have or don't necessarily have rights or interests, but they still warrant protection from the government because they have this like sacred intrinsic value. And when he applies this like example to endangered species, he just says that it would be like a cosmic shame if a species would go extinct, and that's why it has like this sacred intrinsic value, but he doesn't really like further flesh that out or anything. But because he mentions that sacred intrinsic value does not necessarily lead to any rights or interests, this did like beg the question for me when I read about this, how like what the relationship is between moral consideration and intrinsic value, because moral consideration is of course something that we also discuss quite often in like animal legal discourse. And moral consideration, I understand it to be the obligation to recognize and consider the interests of all morally relevant beings in making decisions that might affect them. And I would definitely argue that animals have this like moral consideration in the law as it is right now. You see this through like this prohibition on unnecessary suffering, but also, for example, in the Treaty on the Functioning of the European Union, where Article 13 states that member states should pay like full regard to the welfare requirements. So there's definitely this like obligation to consider the interests of animals. So I do think that beings that have intrinsic value, for example, do have moral consideration, but not necessarily vice versa. So something can have intrinsic value, such as music or art in like the Razian sense, but that does not make it morally considerable. So how does that make sense in terms of the law? Well, then I kind of came to this figure over here. So on the one hand, we have this like intrinsic value of the individual animal, which is implied by its moral considerability and the like prevention or prohibition on its unnecessary suffering, etc. And then on the other hand, we have the intrinsic value of wild flora and fauna as it's recognized in the Berne Convention, for example, or like the intrinsic value of species or biodiversity in international law, etc. And when we have this so this intrinsic value of species, I think that there's first of all two different notions that need to be made with regards to that. And that's that, first of all, the law never really recognizes the intrinsic value of species as such, but only of like rare or endangered or in another way protected species. So in that sense, there's like a deception in the law when it states that it recognizes the intrinsic value of species. And second, the way that the law ascribes this intrinsic value to endangered species seems to be in like this derivative way as meant by res. So rare species are for us a constitutive part of a valuable form of life, and that's why we don't want to like see them or cause them to go extinct, and we regard it as like a cosmic shame. But it is worthwhile, I think, to challenge these assumptions also in light of the rest of the conservation text, which does have a focus in the end on this like anthropocentric and exploitative idea of wild flora and fauna. So to what extent does this really like reflect any kind of interpretation of intrinsic value of species? And then lastly, if we like take the law at face value, there's on the one hand this like collective or species, which has this like derivative intrinsic value, but it does not have interests that like can or should be protected, but there's duties like regarding its existence as a whole. And then on the other hand, we have individual animals that have this like moral considerability and intrinsic value and interests, etc. So in my sense, if I look at the law as such, this would it should definitely be arguable that whenever there's a conflict, the law should accommodate the protection of the interests of these like holders of moral consideration over the derivative value of species in the case of a conflict of, for example, invasive species. But this, of course, would require a shift in the way we look at a law, and this was more, or like a conservation law, and this was more to depict like the way conservation law is right now, or wild animal law is right now. And that's it.